Gamaro Mejia Ortega. I'm gonna learn how to pronounce the first name.
Well, apparently they had his names backwards, which is.
All right, guys, lock in. The judge isn't playing. Defense begs for 30 more days past today's plea deadline, claiming late discovery, old case filed at large, and an ICE hold after a Mexico return. The bench snaps a hard boundary. Final deadline, August 4th. No extensions, period. Clerk sets it, counsel confirms, defendant nods. Courtroom tempo, brisk, unforgiving, crystal clear. Miss this window, and the door slams shut.
Oh,
It's,
okay.
so just, I've been conferring with Ashley, today's our plea bargain deadline.
Yes.
But I wanted additional time because I haven't had time to review all the evidence. And I think there's some potential changes in the plea bargain that may lead to the case working out. I would just ask for an additional 30 days. I just got out on this case in April. The case is old because apparently it was filed at large.
Sure, I think it's,
And he came back from Mexico. There's an ICE hold as well.
So August is going to be your final plea deadline date.
That's all I need.
It will not be extended past that point. Ms. Ferguson, I need a date in August for a plea deadline date, please. All right, August 4th is going to be your plea deadline date. The plea deadline date will not be extended further. Do you understand? All right, thank you. Do you have any questions about anything?
No. Thank you.
Thank you.
Appreciate it.
You're welcome. Thank you. And Norman, can you call Anthony Cantrell, please? All right. Is there a defense attorney in here who has Anthony Cantrell's cell phone? Could somebody text him and tell him he needs to be in the 187 district court, that his client is here on Zoom?
That's the same. I don't know how you feel, because like me, I like find 45 minutes.
All right, thank you. Thank you.
I don't know how many more times. That's the thing, that I gotta go get them, I gotta send them to the corridor, and then I'm taking them back.
Logan, we got a status conference on 729 in Mag Court. We're waiting on a psych report, but they're not bringing him up. And so I don't know, Judge, but it's been hours.
They said I was normal.
Have him on by Zoom. They're going to put him on by Zoom.
Oh, Judge.
Here's the thing, attorneys, your clients need to be here so they can know what's going on.
Routine reset.
No, it's not routine. It's not routine. So everyone, let me just tell you, this is how you all can make my job easier. For clients, this is not routine for them. This is their life. They want to be seen. They want the judge to see them, to speak to them. That's all I'm trying to do. They're going to bring your client by Zoom. Norma, can you have his client by Zoom, please?
The room pivots to logistics chaos. Where's Cantrell? Judge orders someone to text the defense attorney. Client's already waiting on Zoom. Meanwhile, another lawyer complains his client isn't being produced. Judge cuts through excuses. Clients must be present to understand their cases. This isn't routine for them. It's their lives. Decision: put the missing client on Zoom. The message lands like a hammer. Show up, be seen, be heard, or get left behind.
Daryl Payne. And who's your client?
Terrell Allen. You
All right,
talked to first.
just give me 1 second and I'll call you right up.
I think the person most informative in this very
Okay.
file is
Honorable Your Highness,
You're so awesome.
Stephanie, I really need my brother. I will be compliant.
No, just 1 second. They're going to give me an update.
Oh,
Yes.
Judge, all of the evaluations have been completed on Mr. Payne. Unfortunately, at this time, we don't have a solid placement for him. The behavioral health person, director, she was here a little bit earlier, and she indicates that at this point, They are recommending that he just go back with his brother, and once he is back with his brother, they will have a mental health behavioral specialist go to his home and do the treatment there. Immediately upon release, they will have all of the services available to him.
All right, so state.
Yes, Judge.
With Mr. Payne, the whole issue has been that he'll be released. He goes with his brother, he disappears, and then we're back here. So we've been trying for a while to get something stable for him. So they're saying that he can be placed back with his brother. My understanding, the brother wants him placed back with him,
Yes.
and that they will actually do services at his home. So do you have any objections to his being released with that being the plan?
No, Judge, the state does not.
All right, so that's what we'll do then.
Focus shifts to Mr. Payne. Behavioral health evaluations are done. Placement isn't. The director recommends release to his brother, with in-home services immediately upon discharge. The judge lays out the history. Every time Payne's released, he vanishes, and the court starts over. Today, the plan is stability. At home plus a specialist at the door. State has no objection. Green light, care at home, compliance expected, and eyes firmly on follow-through.
Okay, Judge.
So you'll be released. You're probably going to be released at midnight. I have no control over when you're
That's
released.
right.
I'm not in charge of the
I
jail.
understand, Mr. Young.
All right, so make sure you call your brother. I think you can still do collect calls.
Yes, ma'am.
All right, so call your brother and let him know that you're being released, and let your brother know that someone is going to be coming to his home so that they can make sure that you're on your medications and abiding by everything.
Yes, ma'am. I will do right, Stephanie.
Okay.
Last time when I left, I wasn't able to do chores because I wasn't able to walk, but I'm regaining my strength. I tell you, I regain my strength every day. I'm getting stronger.
All right,
I'm able to walk now.
okay, but here, that's a good thing, but here's the main thing. You need to take care of your mental health, all right?
Yes, ma'am.
So the caseworker is going to come out. If there's something with your medications and it has side effects where you don't feel good with it, you need to let your doctor know and let the case manager know.
Ma'am, well, Stephanie,
Don't disappear on
I
us.
promise I won't be honorably behind it. But I'm definitely would.
All right, thank you so much.
Well, thank you, Stephanie, so much.
Oh, you're welcome. And
Bless life.
well, thank you, I appreciate that. Vashawn, if you'll just,
All right, Mr. Payne, listen up. You'll likely be released at midnight. Jail controls. Timing, not the judge. Call your brother collect. Line up the handoff and be ready when the caseworker knocks. Take your meds. Report side effects to your doctor and the manager. Don't disappear this time. Payne vows he's stronger, walking again. Judge agrees that's good. But mental health discipline is the real battlefield. No more ghosting the system. Period.
Make sure.
yeah. And see, do you think we need to do a status or anything on him once he's placed?
I think it'd be good to bring him back in, maybe 30.
All right, hold on for 1 second. Norma, can I have a 30-day reset on Mr. Payne? All right, so keep the reset on. Payne, we're going to call you back to court on August 4th. You're going to get released today,
Yes, ma'am.
but we're going to recall you back on August 4th to see if that everything is going okay, okay?
Yes, ma'am.
All right.
Michelle 5661, Deputy Michelle 5661.
And what page is Payne on? All right, thank you.
The court builds a safety net. A 30-day reset to check compliance. August 4th, same date as the earlier plea deadline, Payne must return. The judge's cadence is intentional. Structure, scrutiny, and accountability. Case numbers are verified, clerks confirm pages, and the bench keeps momentum. This isn't just a release, it's a measured test. Miss the follow-up, and the court's patience, already thin, will evaporate fast.
All right, counsel, if you'll come up. And what is your client's name again, please?
Carol Allen.
All right, so Mr. Montcastle, Ms. Montcastle, your attorney is now here. He's going to confer with the state, and then when he's ready, we'll have him approach.
Okay, thank you. I'd like to confer with my attorney as well, please.
All right, thank you. Just give us a moment. Terrell Allen.
How are you doing?
Oh, I'm doing okay. How are you doing?
I'm alive.
Oh, yeah. Are you all ready to proceed? No problem. So y'all are proceeding on the motion to revoke?
Yes, Judge.
All right, the court is calling 2015 CR 3927 State versus Terrell Allen.
New beat. Terrell Allen. Counsel appears. The state announces it's ready on a motion to revoke. 2 cause numbers hit the docket. A 2015 burglary of habitation probation and a 2019 felony DWI community supervision. Judge confirms identity, dates, terms, and the long paper trail behind Allen's supervision. We're not in speculation land. This is record, compliance, and consequences territory, and the tempo tightens.
Top parties announced.
Duffy Pitlock for the state of Texas.
Brad Thornton for Mr. Allen.
And are you Mr. Allen?
Yeah.
All right. Are you the same Mr. Allen who was placed on community supervision in 2015 CR 3927 for the offense of burglary of a habitation on March 19, 2019 for a period of 3 years? Is that you?
Yeah, long time ago. Yes, ma'am. Yes, Your Honor.
All right, state.
Judge, we also have.
Mountcastle, what are you doing? It's Mountcastle.
Okay, yes.
There's another motion to revoke.
Oh, there's a second motion?
No, there's a second case. It's a DWI.
Oh, I have it. Yeah. And the court is also calling 2019 CR 10147W. Did you review the motion to revoke community supervision in that case as well?
Yes, Your Honor.
Are you the same Terrell Allen who was placed on community supervision in 2019 CR 10147W for the offense of driving while intoxicated third or more on October 11, 2019 for a term of 8 years? Is that you?
Yes, Your Honor.
All right. And excuse me, could I get a file stamp for motion to revoke? And state, are you proceeding on the same allegations in each motion?
Yes, Judge. The state intends on proceeding on one, waiving and abandoning, if you would, when the state can make that announcement.
All right, you may proceed.
So,
Oh, you're welcome, Mr. Payne.
for cause number 2015 CR 3927, the state will proceed on violation of condition number 2, but the state will waive and abandon the other violations alleged.
Any objections to the waivers?
No, Your Honor.
And then in cause number 2019 CR 10147W, the state will proceed on violation of condition number 2 and waive and abandon the remaining violations, Your Honor.
Any objection?
No, Your Honor.
All right, and state if you'll read the violation into the record, please.
Yes, violation number 2 for both cause numbers on or about the 24th day of February 2022 in Bexar County, Texas. The defendant, Terrell Allen, did then and there fail to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that violation in each of the cause numbers, true or not true?
The state streamlines. Proceed on violation condition number 2 in both cases. Failure to submit to drug testing on February 24, 2022. Waiving all other allegations. Allen pleads true. The judge warns, the burglary case can trigger up to 3 years. The DWI case up to 8. Allen acknowledges. Findings. True in both. The courtroom's tone hardens. Admissions made. Sealing stated. And the sentencing. Runway is officially open.
Sure, Your Honor.
Did you understand by pleading true to violation of condition number 2 and cause number 2015 CR 3927, the court could find it to grant the motion and sentence you up to 3 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true, and cause number 2019 CR 10147W. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 8 years in the prison?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 8?
Condition number 2.
I'm sorry, condition number 2. Knowing that, do you still wish to proceed with your plea of true to violation of condition number 2? All right, then the court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Judge.
Yes.
It is different recommendations for the 2 cause numbers. For cause number 2015 CR 3927, the state is recommending termination, unsuccessful, but defendant has already been sentenced on that one. The recommendation for cause number 2019 CR 10147W, the state is recommending continued probation, but to complete state ISF cognitive track followed by ISP.
All right, so are you saying that he's already been sentenced in cause number 2015 CR 3927?
The state does see that this is the second MTR and defendant was adjudicated from deferred.
Okay.
That's what we're under the impression of.
Yes, no, he's on regular probation or community supervision. And so his maximum sentence is 3 years in that cause number. So probation?
Judge, on that cause number, that
Recommendations land. For 2015, terminate unsuccessfully. That supervision's already effectively maxed out. For 2019, continue probation but requires state ISF, cognitive track, then ISP. Defense pushes back on the failure to test. It was an icy day, safety concerns, and no intent to dodge. The judge corrects a record hiccup and recenters jurisdiction. Bottom line, we're here because of missed compliance, whatever the weather.
case expired March 18th of 2022. The court is aware of that.
All right, so and cause number 2015 CR 3927, the court is finding it true. The court will terminate you unsatisfactorily. And just one moment. Right. So then let's move on to the 2019 CR 10147W. State you're requesting ISF?
Yes, Judge. Cognitive track followed by ISP.
All right. Defense?
Your Honor, Mr. Allen, back in 2022, that was the day where there was an extremely bad snowstorm that occurred. And so they called it in to do a test, and he expressed that he didn't feel like he could do it safely that day and wanted to do it a different day. And so he made the decision not to do that. My client, all of the evaluations, we looked at it with probation, has never been evaluated for mental health issues. Yet in dealing with him and talking to his family, he definitely has severe issues. He's been diagnosed, my understanding from dealing with his family, with bipolar depression, as well as what I can see in my interactions with him is at very high levels of ADHD, being able to focus. And so what happened on that day was he was extremely worried, didn't know what to do, panic, couldn't deal with all the problems going on in his life, and decided to freeze and not know how to deal with that. And he hasn't had any issues since then. We think that the proper thing to deal with in the situation is to address those mental health issues now, and that he would be successful in the remaining terms of his probation, and that's what the freeze up was. It wasn't an issue of him using or being dirty. It was him legitimately being afraid because of the conditions on that particular day in terms of being icy. And so we think that this is an appropriate way to remedy both of those situations, is to continue letting him be successful, but also with a cognitive track addressing the issues.
Defense pivots to mitigation, untreated mental health, bipolar depression, severe ADHD, panic during the storm, decision paralysis, no subsequent dirty behavior. They argue for treatment over warehousing, framing the lapse as fear, not abuse. Allen adds family stress and childcare. The ask: targeted cognitive programming to address roots, not symptoms. It's a sober pitch. Meet the illness, fix the behavior, salvage the probation.
Yes. Yes.
On the IC day, I have two kids, right? Of course, the kids have a mom. Mom was in medical school while mom was at the hospital. I only had me. It was me, the two kids, right? And of course, everyone seems say the last dance with Julia Roberts or yes. Okay, yeah. I can't drive. You know, I don't want to take my kids to you can't take your kids anywhere, can you? No, so I mean, I was arguing with the probation officer. I was like, "Can I please go tomorrow?" She's like, "No, Mr. Allen, I have to go."
Okay, so here's the thing. You've been missing since 2019.
For this day.
So, but here's the thing. 2019, do the math. How many years have expired since 2019 and you still haven't come in? The only time you came in was because you were arrested.
22.
Right, Your Honor. And we can present testimony on this, Your Honor. I've talked to his family, interviewed them.
No, I'm just trying to let him know that what he's given me are excuses.
Absolutely.
And these are life. This is life, right? Everybody has different things they have to do in life, right? Now you have some people who say, oh, I'm not going to go to the store today. I'm not going to do this, but there are no real consequences for that. I mean, you don't have something to eat that day. But the consequences are you could potentially go to prison. So since from 2019 to now, have you gone to the grocery store?
Sure.
All right. So you found a way to do that, but you didn't find a way to contact your probation officer and come in. Since 2019 to now, have you taken your children to school? So you haven't taken them to school. So that means somebody else was taking them to school. So you could have come in. So don't come to me with excuses because you haven't done anything since 2019. You understand?
Judge goes surgical. Since 2019, Allen hasn't shown up. Only arrests bring him in. Life is hard for everyone, but probation has teeth. Skip obligations, risk prison. If you managed groceries, you could manage probation. Excuses don't fly. Probation confirms. He drifted near the end of drug court. The court respects second chances, but they require showing up. No attendance, no progress. That's the cold reality.
Probation, what are you requesting?
Judge, the recommendation on Montgomery and Keith State item.
I mean, he hasn't been around since 2019.
We're under the impression it was 2022 when he fell.
All right, so that's still not good because that's 3 years.
He was on the very last end of drug court. In fact, he was waiting for the certificate to graduate from the drug court.
No, and see, that's the other thing with drug court. I know they give people chances, and I know from drug court, and you correct me if I'm wrong, when you don't show up for something for drug court, they don't immediately put you out of the program. Yeah. But they can't help you if they don't see you.
I appreciate you for recommending me to drug court because that helped me out in my adult life, my full life period. Discover a bunch of things. I didn't realize I had a problem. I always thought I don't have. I just didn't want to stop. And
no, I told you had a problem. That's why I sent you to drug court.
I appreciate that, Your Honor. It did help me out tremendously. It's like I always thought I was Superman. It's like how many times have you heard I'm pretty sure I get this a bunch, right? It's like, hey man, you sound white. I'm like, I speak English.
No, I don't get people saying I sound white. If they say I sound white, then that's their prejudice that's coming out. Because what does that mean to sound white? What are you trying to say?
I get it all the time, Your Honor. I'm sorry.
He's talking about himself, Your Honor.
No, okay, so he needs to sign the trial court certification. He hasn't signed that. And probation, did he pay the $57 restitution to SAPD?
Yes, Judge.
Okay. All right, state.
Yes, Judge.
All right, the court is going to grant the motion. Do y'all want to speak to years? His minimum.
We get a flash of insight. Drug court works when you let it. They don't instantly boot you. They search, call, and cajole. But they can't help ghosts. Allen admits the program helped him recognize a problem he denied. Restitution is checked. Paperwork lingers. The bench keeps control, weighing credibility versus compliance. Rehabilitation is a door, not a conveyor belt. You still have to walk through it.
Is 8 years.
Judge, that is the full range. The state has no comment on the range.
All right, thank you. Maybe excuse. Yes.
Have you be permitted to present some brief testimony?
Sure.
Okay. I'd like to call Pamela Williams.
Alan?
Pamela Williams. They call it.
Hello. Hi. Hi. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Pamela Williams.
All right, defense, you may proceed.
How are you related to Mr. Allen?
My grandson.
And you've been part of his life the past 10 years?
Yes.
And so when he first was placed on probation and then did not go in probation, what type of things did you see in terms of what was going on in his life and his ability to deal with problems?
Well, Terrell has been having, we've been telling him Terrell has been having mental problems for a while. He don't deal with things good, depression, bipolar episodes, different things like that. We've been trying to get him to deal with. I think I spoke to you and told you that he just needs some help, you know. As far as I know, I've been trying to help him. He says he's gonna do one thing and then, you know, he bounces back from another. So we've been trying to help Terrell get this thing situated. But I think Terrell needs some help. I'm his grandmother. If I thought, I'm this type of grandmother. If I thought he was a menace to society, I'd tell y'all, do what you got to do. But Terrell needs some help, mental help, Judge. Mm-hmm. He really does. And sometimes they hide things from me. I'm grandma. Mm-hmm. But I've noticed things. You know, he's been through really bad depression. But I think he just needs some mental help. And
let me ask you, there's a time where he was making poor decisions with the burglary and the DWI. Mm-hmm. Have you seen changes in him where he's staying out of trouble and not hanging out with the bad friends?
Oh, he's changed. He's changed. He's so changed. He stayed locked up in the room all day. And so we were even afraid that he was going to, you know, do something. He's changed. He's really changed, but he just needs some mental help.
Have you seen the alcohol or the drug issues that were going on?
No. He doesn't have any.
And you saw that before?
Sure, yeah, I saw it before.
And you haven't seen that now?
No, because I told him when you're a child, you behave as a child, but become a man, you got to put away some things. So I haven't seen those things. And like I say, he really does, Your Honor. He has some problems, some issues that are not, I say, a menace to society. I think he just needs some help. Mm-hmm. And I tell them, I'm the type of grandmother that I tell them the truth about things. Like I'm telling you the truth. I really think he needs some mental health. Terrell is not, I guess you hear this all the time. Mm-hmm. Terrell is not a bad boy. Mm-hmm. He's not. And I just think he needs some help. And that's just.
And if whatever the judge decides to do, whether it send him to prison and he gets out or gives him the help, you don't see the problems in him that were going on back with it. So you're not concerned about alcohol or drug abuse?
No, not at all.
Defense calls Grandma Pamela Williams. She's blunt. Terrell struggles with depression and bipolar episodes, has changed, stays isolated, and needs mental health help, not prison. Substance issues seen before aren't present now, she says. He's not a menace. He's a man in crisis. It's heartfelt, raw, persuasive. The judge listens carefully, but the ledger of missed appearances and broken supervision still sits heavy on the bench.
No criminal belief.
Oh, no, not at all.
Okay, I pass it.
Not at all.
All right, any questions?
No questions from the state council.
All right, so this is what I want you to understand.
Yes, ma'am.
I appreciate your coming down and telling me things about him,
Yes, ma'am.
but I don't want you to go away thinking that help wasn't offered to him, because the felony drug court where I sent him, they have a dual diagnosis problem. So they check for mental health issues. They will give them mental health help. They will give them help with their drug addictions. They do all of that. It is a global wraparound service for people who are in that program. And that's why I sent him there. And felony drug court is different, and these treatment courts are different from different courts, right? From your regular courts, I should say. Now, of course, based upon my knowledge, I will use what I've learned from the different treatment courts in this court sometimes. You know, I see if somebody has mental health issues or if they have a drug issue, then I try to get them help for that.
Right.
And I always tell people, if you have a drug issue, mental health issue, and you let me know about it and I don't give you anything to help with that, then that's my fault. But if you tell me, I'm fine, there's nothing, right? So with regards to your grandson, I knew the issues he had because he was on probation in this court for 2 cases. And that's why I sent him to felony drug court instead of revoking him at that time. Now, felony drug court, when people miss reporting and they go missing, because sometimes people will, what they say, fall off the wagon, go back to their old ways. They will do their best to work with them and try to find them. They have probation officers who will go out to wherever their old haunts were. They will walk, they will go on corners, everything to try to find them, to get them back in compliance before they issue a motion to revoke. So when these treatment courts do a motion to revoke, they've tried everything. There's nothing else for them to do. So I want you to understand that he was offered the help, and he was in felony drug court, and he didn't follow through.
May I speak?
Sure.
Well, I was thinking sometimes they don't really, you say you need help. Everybody say they need help. But sometimes it takes a while for them to realize that they really need help. I mean, really, seriously. For a long time, he didn't think he needed any help.
Oh, no, I understand. That is why.
Everybody was saying he needed help.
No. That is why when he picked up a new charge, because he was previously here for a different felony case, and then he ends up picking up a DWI. That's why I didn't revoke him, because I knew he needed help.
Right.
And that's why he went to felony drug court. And felony drug court is intensive. They have something they have to do every single day. So, you know, you can only offer somebody so much help, and then when they don't follow through, they don't follow through.
Like I said, I think Terrell didn't know. I'm serious, because we've been telling him for years that you need help. But I think he was in the mindset that I don't really think I need help. You know, and I know you said you probably send him different places, and you saw it, I saw it, parents saw it, but I think he just finally began to see it. He really needs.
The judge explains the hard truth. Alan already got help. Felony drug court with dual diagnosis services. Those courts wrap around mental health, substance abuse, and life structure. They even pound the pavement to find missing participants before revoking. When treatment courts file a revocation, they've exhausted options. Grandma counters that insight comes late. The judge acknowledges, but accountability can't wait forever. Offers were made. Compliance wasn't.
He needs help. He really needs help. And I'm asking you, he really needs help.
All right.
Well, give him a chance.
Well, I appreciate you for coming down and telling me things about your grandson.
Okay.
All right. Thank you. You're welcome. Do you have any other witnesses?
No, the witnesses are.
All right. If you'll come forward. All right. So, Mr. Allen, you know that the court has given you a chance, more than one chance.
You helped me out a lot.
Yeah. You were on probation. Then you picked up a new felony. Then I sent you to felony drug court. And felony drug court, they have a dual diagnosis program to work with you with mental health, to work with you with drug issues. Felony drug court, when you And anything I'm saying, if it's incorrect, let me know.
I don't think my grandmother was.
Yeah. No. I'm not talking about, I'm just, what I'm saying now, if what I'm saying is incorrect, let me know. Felony drug court, when you get out of compliance and you go missing, they send people out to try to find you, to bring you back in.
I felt love to drug court.
Okay.
Judge Glenn for mayor, you know, I love Judge Glenn.
All right. So,
Finish felony drug court.
Yeah. Okay. All right. The court is going to grant the motion. The court is going to order therapeutic community, give you credit for any time served. How much time are you asking for, counsel?
With credit for time served?
Yeah, you get credit for time served.
I haven't
So the
figured
range of punishment for him is anywhere from 2 to 8 years. How much are you asking for?
Oh, in terms of being sentenced? Okay, we're asking for 2. And let me tell you why we're asking for that, Your Honor, is because you heard from the testimony that, you know, he's turned his life around. He just has an extremely poor decision-making process. And we think the sooner he gets back in society, the sooner he can build off of where he is now, which is understanding of what's going on. And I think if the court chooses to punish him with that, which we would understand and appreciate, the lowest number to allow him to jump back into society, see his kids, and build off of the good place he is in his life right now would be the best thing for him. So we're asking for 2 years.
All right. I'm going to sentence you to 3 years in the prison.
Decision time. Motion granted. The court orders therapeutic community and asks for punishment arguments. Defense pleads for 2 years. Allen's turning the corner. Kids need him. Momentum matters. The judge weighs it all and lands at 3 years TDCJ with credit for time served, plus the standard warnings on appeal rights and firearms. It's stern but measured. Consequence for years of drift, with treatment embedded.
Give you credit for any time served. I'll request the therapeutic community for you. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
We just now talked about it, Your Honor. I can go over it.
All right, because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you when you're released from prison. If you need anything and I'm here and you need help, just let me know.
May I ask how much back time I have?
Sure. Huh?
May I ask?
We'll find out. I'll tell you. Good.
All right, is the person here on Travis Smith? Lacey Strunk?
Yes.
Yes.
It's from, yeah. Right in the middle of the night.
All right.
No, and the judge ready to.
Okay. All right, what is happening with this case?
Well, Your Honor, I filed a motion to set a bond on Ms. Strunk here.
Are you ready to proceed on the motion to set bond?
Yes, Your Honor. The state does have a recommendation.
All right. And have you all reached a recommendation or no?
We have not, Your Honor.
All right. Court is calling 2025 CR 000308, State versus Lacey Strunk. Can I have parties announced?
Ashley Jones for the state.
Nelson Skinner for the defense, Your Honor.
And are you Miss Strunk?
I'm Miss Burns now, but yes, Your Honor.
I'm sorry?
I'm Miss Burns now, but it was previous.
All right. It says Lacey Burns Strunk. Is that you?
Yes.
All right. Defense, you filed a motion requesting a bond?
Yes, Your Honor.
All right. And state, you're ready to proceed?
Yes, Your Honor.
All right. Defense, do you have any witnesses?
I do. I would like to call Diane England. And
all right, Diane England, if you'll come forward, please.
Over here.
All right, and
Mayberry.
Just one at a time.
Oh.
And to the clerk?
Yes.
I don't have the thing on Strong.
Strong.
Yes, the docket statement. All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Smooth.
You can lower your hand, state your name for the record.
Diane.
All right, defense, you may proceed.
Ms. Allen, you know Lacey Burns Strunk, don't you?
Yes, sir.
How's that?
She's my daughter.
She's your daughter? Where was she brought up at?
In San Antonio.
Here in San Antonio?
Yes.
Is that where you were brought up at?
Yes, actually in Adkins, right outside San Antonio.
Adkins? That's still in Bexar County, isn't it?
Yes, sir.
And you have family members who were here before you? Your parents? Or your grandparents? Were they living here in Bexar County as well?
Yes, sir. All of my family's from here.
For how many generations back have y'all?
Oh, since my great-great-grandfather came from Germany, I guess.
Has Lacey Strunk ever, she's been residing here all her life?
Yes, sir.
Has she ever indicated a desire to leave Bexar County?
Mm-hmm.
She's never threatened to move or
No,
even
sir.
consider it?
No, sir.
Okay.
All right, let's go off the record for a moment. So in the defense motion, he says that she's accused of contacting the complainant about returning the children's coats for cooling weather when he refused to communicate through a third party. Is that what this case is about?
It is.
Yes, sir.
All right, so here's the thing. Step back for a moment. Oh, no, just have a seat.
Oh.
Also, are we proceeding on a violation of protective order for somebody texting somebody to say, please return the children's coats because the weather's getting cold?
That's what their motion amounts to.
Well, no. I mean, I just want to know, is that the allegations?
Yeah.
Your Honor, yes, so there was a protective order that was agreed to in late August of 2022. The defendant then called the complainant several times, and then the last violation is the text about the coats. I will say that this case is just newly indicted, so I have not had a chance to review or talk with the complainant yet, and so we're
All right, so is there any objection to a PR bond with well, I really can't do a PR bond legally.
And that's the issue.
I was going to ask you to do that, Your Honor.
Legally.
Illegally.
So
Oh, no. I will tell you this, illegally, I'm not allowed to do that, but if I could do it, I would grant your client a PR bond. This appears to be a bunch of nonsense to the court.
I think I have maybe $100 cash, Your Honor. Could we do a $100 cash bond?
No, I mean, I can't accept cash here. What are we doing? No.
Take credit cards?
So, no. So, what are you asking for a bond?
Your Honor, the state's asking for a $3,500 bond and a no contact order.
All right, so come forward, please. We're back on the record. State, do you have any concerns for the complainant's safety?
At this time, Your Honor, the state has not been able to make contact with the complainant, and so I can't say from the last conversation we had, yes, he was concerned for his safety. That was, however, back in February of 2023.
All right, so can somebody tell me, what is the basis for the protective order? What's the underlying facts for the protective order, allegedly?
Allegedly, there were a couple of assaults where this defendant is alleged to have committed against the complainant, as well as, I'm not sure the relation of the second victim, but both of those cases were dismissed. However, it seems like there was a tumultuous divorce, and the agreed protective order was the result of those cases.
And then I have a previous, in the defense's motion, he says there was a previous jury trial.
That was out of a different county for a violation of a protective order.
Against this complainant. All right, and it was a not guilty verdict.
It was a not guilty verdict.
All right, so this is what the court is going to do. I'm going to set your bond at $3,500. I'm going to place you on GPS. They'll do it at the jail. I'll ask that the fees be waived. You are not.
New case, new tone. State v. Lacey Burns, shrunk. Defense moves to set bond. The state recommends $3,500 and no contact. Alleged protective order violations include calls and a text about returning the kids' coats. The judge calls it what it looks like, nonsense, but notes legal limits block a PR bond. Background spills out. Prior assault allegations dismissed. A past not guilty on a VPO in another county. Still, boundaries must hold.
To have contact with the complainant. Do you understand? You're not to text him or her. You're not to call them. No contact whatsoever. And with regards to the children's coat, This sounds silly to the court, but guess what? I have no control over that, right? So you need to make sure it's done through a third party. If he doesn't pick up with the third party, I'm sorry, you are going to have to buy extra coats for the children. Do you understand? I don't know why adults can't be adults when it's concerning children, but sometimes they can't. That's when the courts step in. So I'm setting your bond at $3,500. If legally I could give you a PR bond, I would, but I can't. And I don't know the entirety of the facts of this case. I'm just going by what the attorneys are telling me. So that's why I'm setting the bond at $3,500. I don't know about the previous cases involving this complainant, but it's as much for your protection as it is for the complainant, so no one will accuse you of anything. Now, with regards to the GPS, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, if you could state your name for the record.
Lucy Burns.
All right, do you have employment?
Yes, sir.
All right, what is your work schedule?
7 to 30.
All right, so this is what I'm going to do with the GPS. With regards to the GPS, I'm going to do a tracking. They're going to put in the motion the address and the locations where you're not allowed to be. If you violate the GPS, what's going to end up happening is they're going to come back to me with the violation of the GPS.
Can I state something?
Sure.
When this incident first happened and the texting, he turned me in on that then. And they put me on a GPS and I wore it for 6 months and I have not had any contact with it in over 3 years.
So are you still on GPS?
No.
She has had no contact with him for 3 years, and for the 6 months she was on that GPS device previously. And the problem with that, from her perspective, is if the court orders a GPS, the last time the court ordered a GPS on her, she had to sit in jail for 6 days before they got
No, they don't have 6 days here. They have a GPS at the jail. They'll put it on her. Here's the thing. I'm trying to save you money. If, however, you want to pay for it for yourself, you can pay for it for yourself. But if you want the free GPS, it'll have to be done at the jail, and they'll have it done. If we're able to get you back at the jail quickly, they'll have it done at the latest tomorrow.
And you had to go to work, what time tomorrow?
7:30.
At 7:30 in the morning.
All right.
Is that right? 7:30 in the morning?
Yes.
If nobody has any objection, I'll call the jail to see it.
Bond set at $3,500 with GPS tracking. Fees waived if jail installs it. No contact means no contact. No calls, no texts, no just about the coats. Do exchanges through a third party. If that fails, buy more coats. Work schedule noted. Judge pushes the jail to strap GPS tonight so she can clock in by 7:30 a.m. The warning is razor sharp. Violate, and you're right back here. Fast.